Welcome to Pretrial Practice. I'm Professor Randy Dreyer. I developed this course drawing upon my 30-plus years experience as a civil litigator with Utah's largest law firm, Parsons, Bailey & Latimer. The objective of this course is to expose you to the entire pretrial phase of a civil lawsuit, beginning with an initial client interview, moving through the discovery and motion stages, and concluding with a pretrial settlement. The course is practice-oriented and designed to provide you with a realistic pretrial litigation experience through the use of readings, class discussions, a real-life case scenario, and written and oral skills exercises. Since less than 10% of all civil lawsuits ultimately go to trial, pretrial practice is a very important part of the daily work of both litigation and non-litigation lawyers. In this course, you will learn the basic rules, procedures, tactics, and skills necessary to commence and defend a civil lawsuit up to the point of trial. Each student will perform as a lawyer on an actual civil case which was previously litigated in Utah federal court involving the Salt Lake Olympic bid scandal. Students will act as counsel for one of the parties and are expected to treat the model case as a lawyer would in his or her practice. You will perform various pretrial tasks, including drafting discovery requests, taking a deposition, and arguing a motion for summary judgment. You will also maintain a litigation file and keep time records. The goal is to create a real-life experience of litigating a case, albeit in a shortened time period. The course syllabus, which is posted on the course twin page, sets forth numerous deadlines for the completion and filing of written assignments. Lawyers must regularly meet deadlines imposed by courts, opposing counsel, clients, or supervising lawyers. Litigators usually handle many cases at the same time and must manage their time accordingly. Missed deadlines in this course, like in real practice, may result in penalties being imposed. Deadlines may be extended in the rare circumstance where an extension of time is requested from me in advance of the deadline and for a cause that would be acceptable to a Utah judge. The press of other business or other classwork is not sufficient cause. This course is highly interactive and requires the active engagement of each student. All students meet together as a group every Tuesday and also meet on Wednesdays in a small section of 6 to 8 students. The large group classes focus on learning the relevant rules of civil procedure and introducing the week's practical skills assignment. The small sections involve completing and discussing various drafting and other skills exercises. Students will compare their work product with the work product generated by the actual lawyers who litigated the Olympic scandal case. Each student will maintain a litigation file. In that way, each of you will have a file of useful materials to take away from the course. The 10 video lectures which follow this introductory video introduce you to the weekly skills exercises that will be completed and critiqued in your small section classes. You will get direct feedback from your small section professor, each of whom are well-known and highly experienced Utah litigators. The course requirements and the detailed schedule of assignments and classes are posted on the course twin page. Upon successful completion of this course, you'll be able to, 1, evaluate the sometimes complex and competing considerations in assessing a potential legal claim and deciding whether to undertake the representation of a client. 2, exercise the critical thinking skills necessary to identify and resolve common ethical issues and apply recognized best practices in litigating a civil lawsuit up to the point of trial. 3, understand and apply the federal rules of civil procedure relevant to the pretrial phase of litigating a lawsuit. 4. Draft pretrial litigation documents, including retainer agreements, pleadings, motions, discovery requests, Rule 26F reports, and settlement documents. 5. Notice, prepare for, and take a deposition of a fact witness and/or a corporate representative. And finally, demonstrate the ability to prepare for and orally argue a motion for summary judgment. Many former students have observed that this class was the most useful course they took in law school. The course is admittedly a lot of work, but the practical knowledge gained will better prepare you to begin your legal career upon graduation. And we're going to have a lot of fun too. See you in the first week of class.